So what happens if you get sued for credit card debt, especially by a junk debt buyer? What are some of the things you should do? What are some of the things that other people do wrong? What is the best way for you to handle a credit card junk debt lawsuit? My name is Michael Wasylik. I'm one of the lawyers at Ricardo and Wasylik in Florida. And with my partner, Jason Ricardo, we help people just like you overcome debt collection with dignity. And today I want to talk about the way that credit card lawsuits normally proceed, the way most people handle them, the mistakes that many people make, and what you can do differently to get a better result. So here's what the normal process looks like. First of all, in a normal credit card lawsuit process, first of all, the folks who are doing the suing are almost always junk debt buyers. And what that means is that the credit card companies, once they determine that a debt is probably not going to be paid, a bill is not going to be satisfied, they will write off the debt on their books. They'll do a charge off. And then they'll sell bundles of accounts to junk debt buyers who buy them for pennies on the dollar. They hope to squeeze nickels, dimes, and even quarters out of the people whose names are on that list that they've purchased. Now, notice that I said a list. Junk debt buyers don't really buy the accounts, they don't buy the contracts. What they really buy is an Excel spreadsheet or a spreadsheet from some other software. And what they get is a list of names, account numbers, and amounts due and owing according to the credit card company. They don't get any underlying documents, and in many cases, the contract between the credit card company and the junk debt buyer actually says, we don't make any representations about the accuracy of the information we're giving you. So the junk debt buyers know they're buying garbage. What that means is they pay very little up front for it, and they try to squeeze as much money as they can out of these lists that they purchase. And the way they do that is twofold. First of all, they will start doing phone calls and letters to the people on the list. Those are collection communications. Those are not court action. And so they will offer you discounts. They'll say, if you owe $1,000, we'll take $700 or something like that now. And the reality is they've paid, maybe $5 or $10 for that $1,000 debt. And so anything they make is profit. Anything you pay them is profit. And so very many cases you can negotiate very deep discounts with them. But if there's no response to the collection communications, if there's no response to the phone calls and the letters, what they may then do next is they may file lawsuits. And companies like Midland Funding, Portfolio, you have LVNV, and you have Cash LLC, and companies like that, they buy up these lists of people, these credit card lists from the credit card companies, and after the communications don't work, then they will file these lawsuits, and they file thousands and thousands of lawsuits across the state of Florida every month and drag people into small claims court for debts that are $1,000, $1,500, $2,000. Florida Small Claims Court as of 2020 was raised to $8,000, so you may see small claims cases for $8,000 or less. Most of the debts bought by companies like Midland, by Portfolio, LVNV, and Cash are usually going to be within the $1,000 to $5,000 range. That's the vast majority of the credit cards, the accounts that they buy, the lists that they buy. Those are what the balances are. So they will go to small claims court, and that's where this process comes in. This is the lawsuit process. Once collection communications have failed, they will prepare a lawsuit in small claims and they will file it. That means that they take the paperwork, they submit it to the court. In Florida, you can do that electronically now. So, and you can pay the filing fee online. So now it's very easy for companies like Midland, Portfolio, LVNV, and Cash LLC. It's very easy for them to file hundreds of lawsuits at one time in any given county because they're doing it electronically. They're doing it they don't even have to go to the courthouse anymore. They do it from their desk, and they can pay the filing fees with their own accounts by credit card or whatever. So they file these by the hundreds. Okay, now the next step is for each individual that has been the target of a filed lawsuit, then the next step is they have to serve that lawsuit on the person who's being sued. What that means is that a process server has to come to your door where you live and deliver a copy of the complaint, which is the document that outlines the charges against you, not the charges, but the claims against you, and along with a summons. And in Florida, with a small claims action, there will be a court date affiliated with that. So when the process server will come to your door and they'll say, "Are you John Smith?" And if you are, then they will say, "This is for you." There's no special language required. You don't have to sign for anything, but they do need to find out who you are in order to serve you. They will probably ask you if you live there. They can also serve your spouse or anyone else over the age of 15 who lives in the property with you. So if you have roommates, if you have family that live with you over the age of 15, the process server can say, "All right, well, if you're not John Smith, does John Smith live here?" If the answer is yes, "Do you live here as well, and are you over the age of 15? If the answer is yes, please make sure John Smith gets this," and they can walk away, and John Smith has now been served. Now, what needs to be in that package that they deliver? They need to have a copy of the summons. They need to have a copy of the complaint, which again is the list of claims against the person being served. And that complaint will usually contain copies of credit card statements. The complaint identifies who is doing the suing and who is being sued and what the claims are. And almost always in Florida, the complaint will say it's an open account. Sometimes they'll add an unjust enrichment. What that means is that they say that we mailed you a statement, or the credit card company mailed a statement to you. You didn't object to it. Therefore, we're going to pretend that you agreed to it. And because you agreed that that balance was true and you haven't paid, we're now suing you for it. Now, what happens when you get served? Well, like I said, the summons will tell you, for small claims court, it will say there's a court date that has been set, and it'll give you a date, it'll give you a time, it'll give you a place to appear, and you are required to show up in court on that day. And it doesn't matter if you've got work, it doesn't matter if you've got something else going on, you might be out of the country, or whatever. If there's a date and a time listed and a place, that's where you're supposed to be. Now, I'll talk in a minute about ways you can avoid that. That comes in the how you can do things better. But for right now, we're talking about what happens in most cases. So John Smith receives the summons. It says, you've got a court date of June 1st, 9 a.m. Here's the address of the courthouse. You need to be there in that courtroom to answer the claims against you. In small claims court in Florida, you're not required to serve a written response. For other types of lawsuits in Florida, you often do. For small claims court, you don't. Now, your summons will say, if it's small claims court, your summons will say if it's county court or circuit court. So make sure, if you get served, make sure to read the paperwork you get. It will tell you have to show up for a court date, or you have to file a written response to the complaint. If it says you have to show up at a court date, then you need to show up at that court date. What happens if you don't show up at the court date? Well, if the person suing, if the plaintiff suing you has records that you've been properly served and you don't show up for the court date, the judge will then say, a default is entered against John Smith. What does that mean? A default is essentially an admission by the defendant being sued that the charges, the claims are accurate, and a judgment can be entered. Now, that means it's like if you don't show up, if a football team doesn't show up for a game, they forfeit the game. If you don't show up at your court date, you're forfeiting your right to contest the lawsuit that's being served on you. So it's very important to show up at that court date. When you show up at the court date, there will be, usually there's like 40 to 50 other people there, depending on how busy the particular court is. And the judge will call the cases in order, and they will call up each individual, and they will ask, John Smith, are you here? Yes, John Smith is here. Please approach. John Smith will walk up to the podium. The lawyer for the plaintiff, the junk debt buyer, will walk up to the podium as well. depending on the courtroom setup, there may be tables, there may be a podium, whatever. Every courtroom's slightly different, but most of the time there's a podium for the parties to walk up to with a microphone. And the judge will then ask the defendant, John Smith, do you admit or deny the debt? Do you admit or deny that you owe this money? And here's one thing most people do wrong. Most people will say, oh, I mean, yeah, it's mine, but I can't afford it and I need to work something out. Until and unless you've read that complaint and you know exactly what's going on, you can always admit something later. If the judge asks you whether you admit or deny the claims, you should say it first, like, if nothing else, Judge, I don't know. And so at this point, I'm just going to deny it. If you are certain you're denying, you can say I'm denying it, but say just for right now, Judge, I think I need to deny this because I don't know, I don't understand what these things say. I don't understand what the legalese means. I don't understand what the claims are or whatever. Because I don't understand it, because I'm not a lawyer, I'm going to deny the claims in the complaint. If you admit the claims, you are allowing the court to enter a judgment against you. We'll talk about what happens after a judgment's entered. So in most cases, whether you admit or deny, most small claims court have a mediation requirement. What that means is that the court will encourage the parties to talk to each other about settling the case, and they will bring in court mediators whose job as a neutral third party is to assist the parties in coming together to some kind of settlement agreement. What that means is that the mediator will take both parties into another room. They will then say, all right, so plaintiff, you're the one suing. Tell us what you think the case is about. And the plaintiff will say, oh, well, John Smith opened up this credit card. Here's the balance. It was never paid. And the last statement was made on this day and was not responded to. And so we're asking for a total of $1,500. And then the mediator will turn to John Smith and say, okay, your defendant, Mr. Smith, do you have a response to that? What do you think about that? And John Smith will then have a chance to tell their side of the story to the mediator. Now, the mediator doesn't make any decisions. The mediator is not someone you need to persuade. The mediator is not somebody who is going to impose anything on you. Their job is to help the parties come to a mutual agreement if they can agree. And so what the mediator will do at that point is, after John Smith says, well, I don't know what this is all about. I don't recognize this debt, or I vaguely remember getting a credit card some time ago, but I don't know if these numbers are right. Or maybe John Smith just says, yeah, it looks like mine, but I can't pay it. I can't afford it. Then the mediator will tell the parties, okay, well, maybe there's a payment plan, or maybe you can agree halfway, or something like that. Partial payments or payment plans are often the result of the mediation. But no one can make you offer to pay money at this phase of the litigation. No one can make you mediate. No one can make you settle at a mediation. They can make you mediate. They can't make you agree to anything. So if there's no settlement agreement, that's called an impasse. The parties then go back to the courtroom and they will report to the judge, or the mediator will report to the judge, Judge, we didn't reach an agreement, so now we need to set this matter for trial. Now, the trial is the phase of the case where the parties present evidence and let the judge make a decision about whether or not money is owed, and if so, how much. The trial date is almost never the same date as the first appearance. A trial date will usually be 30 to 60 days out, depending on the schedule of the court and how many cases they have to set for trial. It will also, if there's a trial date, that will also give the parties some limited time and powers to investigate and prepare for the trial itself. So what will happen is, if the mediation results in an impasse, then the court will set a trial date 30 to 60 days out, and then the parties have to come back to trial. Again, if you don't show up for your court date, you will lose by default. You will have a judgment entered against you, and things flow from there. Now, at the trial, the parties have the right to present evidence. The parties have the right to challenge any evidence brought against them and make legal arguments. Here's something that's really important. Even in small claims court, where the rules are somewhat relaxed, the judge is required by law to treat you just like anybody else who shows up in court. Lawyers who know the rules of evidence, who know the rules of procedure for small claims, and parties who choose to represent themselves are held to the same standard. The judge will expect you to know how to present evidence. The judge will expect you to know the law that governs the claims against you. The judge will expect you to know, with some limitations, the rules of procedure. Most judges do a good job of explaining what's going to happen, but still, you're required to obey the rules of procedure. Once the judge explains them, you're not really going to get a second shot to relearn it. You need to know what you're doing before you go into trial. And there's ways you can look that up online if you want to do that. If you want to represent yourself, you can. But remember, you'll need to know the rules of evidence, you're going to need to know the rules of procedure, and you're going to need to know the substantive law of the claim against you, which, again, in most cases like this, is an open account. So you'll need to know what the other side needs to prove. You'll need to know which evidence is beneficial for you to keep out, which evidence is not going to help them prove their claim. So to make that argument that, Judge, they didn't prove their claim because they forgot to introduce this item or this item or this item, you need to know that. If you're going to represent yourself at trial, you're going to need to know the rules of evidence, the rules of procedure, and the substantive area of the law that is governing your claim. Now, after the trial, after the parties present evidence and make all the legal argument that's relevant, what the judge will do then is the judge will decide, does the plaintiff have a right to recover money from the defendant? And if so, how much? And if the answer is no matter what the judge decides, they will enter a judgment in favor of the defendant or in favor of the plaintiff. If the judge decides the plaintiff has failed to prove that any money is owed, it will enter a judgment for defendant. Defendant goes free and doesn't have to answer to that claim ever again. Okay? If the judge decides the plaintiff has failed to prove its case. But if the judge decides that money is owed, and it can be $1, it can be the full amount of the claim, whatever that amount of money, the judge will enter a judgment for that amount of money plus court costs. So, and that is the filing fee that the bank has to pay, or the junk debt buyer pays when they file their initial lawsuit, which is usually a couple $100. So you'll have a judgment against you for the amount of the debt, whatever the judge decides it is. So, for example, John Smith may have a judgment for $1,000 and court costs of $250, and the judgment will also provide for interest to run on the judgment amount. So if it's not paid right away, the judgment will provide for interest at a certain percentage rate, depending on what the agreement says, or depending on what the law provides in the absence of a contract. So Florida has what's called a judgment rate. It's set by statute, and the Office of the Financial Affairs, I forget exactly which office does it, but it's part of the Office of Financial Regulation, rather. So there will be a judgment with the principal balance owed, with interest and court costs on top of that. Then, if the judgment is not paid, typically within 30 days or so, or actually usually when the judgment is entered, the judge will require the parties to answer what's called a judgment information form, a debtor information form. And what that is, it's a list of your finances, basically. What are your bank accounts? What kind of vehicles do you drive? It requires you to disclose all of that information in order for the plaintiff to have an idea of where they can go to collect that judgment amount from you. So, and you have to do it within 30 days. If you fail to answer it, you may be held in contempt of court. In extreme cases, you can go to jail for failing to respond to that. So if the judgment is not paid, you have to fill out that form. You have to tell the plaintiff where they can take your money from. And so what will often happen then is most people don't pay that judgment right away. And so then you go to what's called execution. And by execution, I'm not talking about the death penalty. I'm talking about the act of collecting on the judgment. That's called execution on the judgment, and it can take many forms. It can take the form of seizing money out of bank accounts. It can take the form of seizing vehicles or real estate. It can take the form of, most commonly, garnishing wages. And so that's what we see most often is that folks are being subjected to wage garnishment because the plaintiff finds out where they work and sends a garnishment notice to the employer. So your boss knows that you're being garnished for a judgment, and your employer has an obligation when they get that garnishment to take wages out, to take money out of your paycheck and hold it for the plaintiff to recover if the judge later determines that they're entitled to do that. And here's the tricky part. Judgments can last for 20 years in Florida and can be renewed, which means you may have a judgment out there you don't even know about or don't even remember. And 10, 15, 19 years later, you may find yourself having your wages garnished. And that means that the plaintiff has decided that they are actually going to go after you. So that's the execution phase. Garnishment of wages, seizure of bank accounts, seizure of vehicles that are paid off, seizure of real property and other assets that you may own. Most common, it's garnishment of wages for small claims court because the amounts in question are usually pretty small. So that's what the normal process looks like. And all too often, we have people come to us in the later stages of this. They've made a mistake. They come to us only after they've gotten to the execution phase of the court case, which means that they're having their wages garnished and they may not remember or even know about a judgment being entered against them. Maybe they missed their court date. Maybe they showed up for court and didn't know what to say, and a judgment was entered against them, and or maybe they showed up in court and they admitted the debt and a judgment was entered against them, and now they're getting their wages garnished. And now suddenly they decide they want to do something about it. This is usually the wrong way to do it. This is the process that happens if you just kind of drift along with the current and go with the flow and just see what happens. But if you want to take control of the situation, there's a better way to do it, and I'm going to talk about that right now. So, when you are dealing with the credit card junk debt buyers, this is a better process. This is the process that we help people with. What we do is you can see this is a much shorter process. This is a much simpler process. What happens is the junk debt buyer will file a lawsuit against you. Okay? They will file that. They will serve it. You will get the service of process at some point. And from that point, that's when you take action. That is when you need to jump in. At the point you are served and a court date is listed on your summons, you have a duty to do something. You have an opportunity to do something that most people miss. And that opportunity is you get help from somebody who knows how to handle these. Our firm does these type of cases on a regular basis for people all over the state of Florida. And we recommend that whether you call us or you call someone else, you definitely speak with a lawyer who knows how to go into court, who knows how to go into small claims court and beat junk debt buyers. You want a lawyer who knows how to handle Midland, how to handle Portfolio, how to handle Cash LLC, and how to handle LVNV, or anybody else who claims to have purchased the debt. Again, when they serve you with the complaint, there'll usually be some indication the credit card company was over here and we're the company that purchased the debt over here, and they'll attach like a bill of sale or something like that. And so you'll know immediately if you read your complaint whether you're dealing with a junk debt buyer, and if you are, you want to attack it right away. Even if you're not, if you're dealing with the original credit card company, whether it's Chase or Capital One or Amex or Bank of America, all those companies do file in their own names. Sometimes, not always, but sometimes. So you'll still want to intervene at the process where you get served. You'll want to seek professional help. And what you'll do is you'll call a lawyer who can assist you with this. Now, I'm going to give you this number again in a little bit, but our number is 352-567-3173. That's 352-567-3173. If you're watching this video, I'm going to put that number in the comments or the description so that you have it at hand. You can call us easily if you've been served with one of these lawsuits. Now, when you call, you will then tell us about Here's the complaint I got served with, and so on and so forth. Now I'm going to address the elephant in the room. Most of you are thinking, but I can't afford a lawyer. I can't afford to have somebody help me out with this. In most cases, that's probably not true. In most cases, you're probably wrong. And the reason that you're wrong is not because you're not smart enough to deal with it, but because you probably aren't familiar with the way lawyers handle these type of claims. It is usually very straightforward to get in these. So I'm going to talk about the rest of the process, and I'm going to leave for the last the part about why you should not decide not to call a lawyer because you don't think you can afford it. Do make the phone call, find out what the cost is, because you'll probably be surprised at what that cost is and how reasonable it might be for you. So at this point, once you've been served, you call a law firm, you call Ricardo and Wasylik at the number we've given you below, and you give us a copy of the complaint. And then if we reach an agreement and you decide to hire us to help you out, then what we will do is you don't have to go to this court date now because we do that for you. You don't have to worry about the mediation. You don't have to worry about the trial. You don't have to worry about judgment or execution because we will do all that worrying for you. What we will do is before the court date even comes up, we will reach out to the other side and we will propose a settlement offer that is within your means. Now, I will tell you that many times, because of the economics of the junk debt buyer business, it doesn't make sense for the junk debt buyer to fight against someone who has experience litigating. It costs them more money than it's worth. It's too much trouble for them. If they're only going to make a few $100s, the cost of them to hire a lawyer to go do battle at trial with somebody who knows the rules of evidence, the rules of procedure, the substantive case law, it's too expensive. It doesn't make economic sense for them. So we can settle those claims for a lot less money than you might think. And in many cases, if the case is particularly weak, if the evidence is particularly flimsy, which in many cases it is, or if the amount is unusually low, we can settle for very little or no money in many, many cases. So that is often possible. And so you can actually have this whole thing done for less than if you had tried to settle with them outright at a mediation if you went on your own. Because you'll pay more to them than you'll pay to us to get the thing thrown out entirely. So we reach out to the other side and settle. And then after the settlement is reached, you're done. You don't have to worry about trial. You don't have to worry about a judgment following you around for 20 years. You don't have to worry about having your wages garnished. You don't have to worry about going to court. You don't have to worry about any of this part. Because if you get into the process at step number 2, which is when you're served, and you get professional help, the next steps are settle and done. So if that's something that you think you'd like to do, if that's something that you think you would like us to help you with, then call us now. Now, again, if you've been sued for a credit card debt, if you've been sued by a junk debt buyer, you can choose which of these two processes you want. You can do the normal route, or you can use the better process. You can do the normal route, which is multiple steps, lots of time away from work, lots of time away from your family, potentially lots of harassment down the road and extra cost to you, or you can have us take care of it for you. So that's the way we do it, and that's the route we normally recommend. Now, let me also add this. In many cases, we are able to identify ways in which some debt collector, some junk debt buyer has broken the law. And if they break the law, they may actually owe you more money than you owe them. So that is something that we're always on the lookout. That's why we want to see as many of these cases as possible, because let's say, for example, John Smith has more than one case involving a credit card. Well, if we can find, let's say they have 3, John Smith has 3 cases. If one of them involves a junk debt buyer or a debt collector that breaks the law, and we can actually put money in his pocket, then the other cases can be taken care of as well. So in this situation, if there is a violation, it can actually end up making money for the person who's been sued, which is kind of unusual when you think about it. So there's the regular process, there's the better process. When you get served, you get to choose. If you are completely convinced that you want us to help you with this, give us a call. Again, the number is 352-567-3173. That's 352-567-3173. Mention on the phone that you saw the better process video, and when you speak to our staff, they will schedule you for a free 30-minute appointment to talk to one of our lawyers. We don't usually need 30 minutes to figure out if we can help you, but you get up to 30 minutes. And there's no risk, no obligation to you. You call the phone number 352-567-3173, and we guarantee you that that 30-minute appointment will give you more clarity, more information, and a better idea of what you need to do next in order to get to done. So thanks for watching. I really hope that anybody who's watched all the way through to the end, I know you're probably the ones that most need to give us a call. So give us a call at 352-567-3173. We look forward to hearing from you.